$10,700 million. That is what the Sackler family extracted from Purdue Pharma between 2008 and 2018. Not stolen, not hidden in a suitcase. Extracted, legally, methodically, through dividends, distributions, and internal transfers that any competent estate attorney would recognize as textbook. Not one member of the Sackler family ever personally filed for bankruptcy. Sit with that before you decide what kind of story this is. Here is the version you were sold. Purdue Pharma, the maker of OxyContin, collapsed under the weight of opioid litigation. Thousands of lawsuits, state attorneys general circling, a company buried by its own product. And so, like any company crushed by liability it cannot pay, Purdue did what broke desperate entities do. It filed for Chapter 11, bankruptcy protection, in 2019. The public read that filing the way the public reads every bankruptcy, as collapse, as the machinery of justice finally catching up to a family that built a fortune on addiction. The assumption was simple and, frankly, comforting. If the company is bankrupt, the family must be bleeding too. Fortunes don't survive the fall of the businesses that built them. That's the story we tell ourselves about consequence, that it's proportional, that it eventually arrives, that the money and the misery are tethered. It is a comforting story. It is also, in this case, almost the exact opposite of what happened. Here is the inversion, and it is worth sitting with because it inverts everything you think you know about what bankruptcy is for. The extraction came first. Years before Purdue Pharma ever walked into a courtroom asking for protection, the Sacklers had already walked the money out the back door. $10,700 million, pulled out over roughly a decade, accelerating specifically in the years after litigation risk became undeniable, after state began filing suit, after the writing on the wall was not just visible, but illuminated in neon. The family didn't wait to see how bad it would get. They read the exposure, calculated the endgame, and moved the capital before the endgame arrived. Then, once the company had been sufficiently hollowed out, once there was functionally nothing left inside Purdue Pharma worth seizing, they filed the empty shell into Chapter 11. This is the part that should unsettle you. Bankruptcy, in the popular imagination, is where value goes to die. In this case, bankruptcy was not the crime scene. It was the exit architecture. The Sacklers didn't file because they had no money. They filed because bankruptcy court offered something no civil courtroom, no state attorney general, and no amount of personal wealth could offer them individually. A mechanism to bind plaintiffs who did not yet exist, to a settlement they did not yet know they'd need. In exchange for protection, none of them had personally earned through insolvency. That mechanism has a name: non-debtor third-party releases. Here is what that actually means, stripped of the legal upholstery. When a company files for bankruptcy, the court can approve a plan that releases the company from certain liabilities in exchange for a negotiated payout to creditors and claimants. That much is standard, unremarkable, the basic machinery of reorganization. What Purdue's bankruptcy attempted was something else entirely, extending that release not just to the company, but to the Sackler family personally. Individuals who never filed for bankruptcy. Individuals whose personal balance sheets, offshore holdings, and trust structures were never opened to discovery, never audited by a bankruptcy trustee, never exposed to the scrutiny that any actual insolvent debtor would have to endure. In exchange for a capped financial contribution, negotiated, deferred, and dramatically smaller than what had been extracted, The Sacklers would be permanently shielded from present and future civil lawsuits related to the opioid crisis. Present plaintiffs. Future plaintiffs. People not yet born who might one day have a claim. All of them bound by a court's jurisdiction over a company to release liability against individuals who were never debtors in that case at all. And the leverage worked because of the shell that extraction had created. By the time state attorneys general sat down at the negotiating table, Purdue Pharma had nothing left to seize. No assets, no cash reserves, nothing but a corporate name attached to a product that had already generated its return. The states faced a binary with no good option: accept the negotiated settlement or spend years litigating against a corpse with an empty pocket, chasing a judgment that would collect against nothing. The extraction hadn't just moved money. It had engineered the negotiating position of everyone left standing. Now, the numbers, because the numbers are the entire argument. $10.7 billion extracted. The eventual settlement, after years of negotiation, litigation, and public pressure, landed at approximately $6 billion, paid not in a lump sum, but structured over nearly 2 decades, discounted for present value, deferred against inflation. A fraction of the original extraction stretched thin across years the family would spend, by any reasonable estimate, comfortably. Individual victims' families, people who lost children, spouses, parents to a product this family's company manufactured and marketed, received payouts frequently in the low 5 figures. Not life-altering sums. Administrative sums. The kind of number that settles a lawsuit without settling a life. Meanwhile, portions of the extracted wealth remained parked in offshore trusts and international holding structures, legally separated from the settlement negotiations, largely untouched by the very proceedings meant to address the harm the underlying company caused. And then, in 2024, the architecture cracked. The Supreme Court, in Harrington versus Purdue Pharma, ruled that non-consensual third-party releases, the exact mechanism the entire settlement depended on, were not permissible under the Bankruptcy Code. The court found that bankruptcy protection could not be extended to individuals who had not themselves filed for bankruptcy, no matter how convenient that extension might be for resolving mass litigation. The entire negotiated structure, years in the making, collapsed. Everyone went back to the table. The Sacklers this time, from a considerably weaker position. The shield gone, the leverage reduced, the calculus changed. But notice what didn't collapse. The $10.7 billion had already been extracted. The years had already passed. The interest had already accrued elsewhere. The ruling closed a door after most of what mattered had already walked through it. Here is the part worth remembering long after the Sacklers are a footnote. This was never about hiding money. Hiding money is what amateurs do. It's crude. It's traceable. It eventually surfaces in a subpoena or a forensic audit. What the Sacklers did was different in kind. They didn't conceal the extraction. They used the court's own procedural architecture to make the extraction irrelevant. They found the exact mechanism inside a system designed to handle insolvency and repurposed it to manufacture liability protection for people who were never insolvent at all. That is the actual asset class of generational wealth. Not cash, not real estate, not even the underlying business. It's the architecture, the legal instruments, the procedural leverage, the willingness to treat a courtroom not as a threat, but as infrastructure to be engineered. Money can be traced. Structure is harder to prosecute. because structure isn't hidden. It's filed in plain sight, approved by a judge, and defended as procedure. The wealthy don't typically break the rules. They find the rule nobody else thought to weaponize, and they get there first. The Sacklers didn't need to hide $10,700 million. They needed a court willing to make the hiding legal, and for a while, they found one.